introduce today's moderator. Michael Renaud is a member and firm-wide chair of the IP division at MITS. He has been continually recognized as one of the world's leading IP strategists. I found this nice quote from one of Mike's clients, which I think nicely sums up why Mike is ranked on that list year after year. Mike is extremely good at developing cases, budgeting appropriately, and assessing the scope and shape of the risk confronting his clients. Plenty of lawyers have the technical ability to handle complex patent matters, but Mike has a special understanding of and sensitivity to business issues that sets him apart. You can find the rest of Mike's bio, along with the bios for all of our speakers, up top by clicking on the View Schedule link. With that, I will turn it over to you, Mike.
Thanks, Wendy. Much appreciated. So we're excited to have such a great panel. Wendy is correct. This is the second part of a dialogue. Some of you were likely at the first session. We're going to try to avoid overlap, but we've got a completely different panel and I think some great points of view. So without further ado, let me introduce the panel. We have Tim Burgess, who is the president and strategic advisor to Celerity IP. It's a subsidiary of GLS Capital and a leading provider of commercial litigation finance solutions. Tim is also the founder and president at TJB IP Consulting. Prior to his present role at Celerity and TJB, Tim served in various roles at InterDigital, including as chief licensing officer. Tim was at InterDigital for over 19 years. Sticking with Wendy's thread of using a quote, I'll say what's interesting is Tim is one of the few licensing executives that actually has been, personally identified in some of these court findings. Lord Mead over in the UK noted in the Optus v. Apple opinion, Tim's experience is deeper, more relevant, more focused on the reality of FRAND licensing. So that actually found its way into an opinion. So we're delighted to have Tim as part of the panel. Tim also holds an MBA from Northwestern University's Kellogg School of Management and a BSME from Marquette. Moving on to the second of our three panelists, Kimberly Chakowski. Kim is president of Brandywine Ventures, and similar to Tim, has a legacy of having worked for a number of years at InterDigital. Kim was vice president, head of licensing strategy and operations. Kim has a wealth of experience in the IP space, including 18 years as a patent litigator and licensing and prosecution experience. She also has been listed in Intellectual Asset Management's 300 IP strategists, top 300 IP strategists in the world. Kim also holds an electrical engineering degree and a BS in Humanities and History from Worcester Polytech and a JD from the Franklin Pierce Law Center, as well as an MBA in International Business and Finance from Sacred Heart. So delighted to have Kim and Tim on the panel. And then last but not least, Hassan Rashid. Hassan is the Associate General Counsel for licensing at General Electric and Senior Advisor on IP strategy, including standard essential patents and FRAND licensing. Hassan was previously Chief IP Officer at HEVC Advance and was a partner at McDermott, Will & Emery. Finally, Hassan also has a JD from the Boston University School of Law and both an MS and a BS in electrical engineering from the University of Florida. So we got an awesome panel. As time is always tight in these things, why don't I jump right in, and I'll start off with you, Tim, if you don't mind. Tim, do you think there's confusion about enforcing SEPs at the ITC?
I do. I think it, it does kind of stem back. It was a fairly popular form in the early 2000s for SEP holders. And then, I think in 2013, the decision, Samsung versus Apple, added a lot of uncertainty to the ITC. And I think people started to look at different forms, different jurisdictions, to try to get SEP deals across the finish line. I think it is still part of a strategy, but there is a lot of uncertainty.
And Kim, when following up on the question and the answer from Tim,
Yeah.
what can you tell us about the current policy in the United States regarding SEPs, or your thoughts generally about that?
Yeah. In 2019, the USPTO and the DOJ issued a joint statement. So it's changed a little bit here, where they've stated that, remedies should be under all national law, and that would include injunctions as well. And so there is this ability, and SEPs and France should come under that as well. So there should be an opportunity for companies and organizations to be able to enforce in ITC and find an injunction.
And as a follow-up to that, Kim, are to the extent are there any recent cases that provide some insight on the ITC's willingness to adjudicate SEPs?
Yeah, recently the Netlist Hynix case, that kind of gave some willingness for the ITC to get in there with the SEPs and adjudicate that kind of a dispute. It was overturned on different grounds, but what it really did show was the willingness for the ITC to take this kind of an issue up. So there's still some uncertainty, but it definitely has changed kind of the outlook and where people are really looking at what you could do with the SEPs and the ITC.
And turning to Hassan, feel free to elaborate on any of the two questions that I've asked already, which were kind of introductory questions. But are there any recent cases that provide additional insight on these issues?
Yeah, so we're getting kind of slowly through U.S. courts what FRAND is not, I'll say. So compared to some other jurisdictions around the world, in the FTC Qualcomm case, FRAND is not an antitrust issue, according to the Ninth Circuit. We also got some guidance that said, there's a difference between patent damages that should go to a jury and FRAND, which could be decided by a judge. And most recently, the big news was the HTC Ericsson case out of the Fifth Circuit, which touched on a lot of these same issues, sort of recognized an interest and ability to consider willing licensee disputes, but really kind of driving a line between what a FRAND rate is and what patent damages are, which will be an interesting line of cases to see, how the U.S. Develops as far as how to calculate a FRAND rate.
And just back to you, Hassan, again, given the current uncertainty that we're discussing, what factors do you think should SEP holders consider when looking whether or not to bring an ITC action?
Yeah, it's the same factors you'd apply if you're considering venues anywhere around the world. What's the predictability of the venue, and what's the cost? In the ITC and in the U.S., as I said, we're learning tidbits here and there of how a court or the ITC would go about a FRAND analysis. But we don't really have the predictability I think folks want to see, especially for jurisdictions and venues that are the most expensive in the world. That said, the U.S. is a huge market. And when it comes to getting an injunction, the highest level of relief you can get, the ITC is a better option than the U.S. district courts because of the eBay decision.
It's an interesting set of affairs. I think the stops and starts that we've seen in Germany and the UK in particular, I think you're correct. They are further along than the U.S. The U.S. is kind of playing catch up. And oddly enough, I think both Tim and Kim pointed out the history at the ITC is still a little unsorted, but the door is clearly open at this point. Whether it will stay open is an interesting question. But it leads to the next question, which I think I'll probably end up asking each of you your thoughts. But I'll start with Kim. There is the ITC has the so-called 100-day program. They also have a new program, which is the early disposition program, which is essentially mirrors the 100-day program in regard to trying to front load issues. Any thoughts on whether it be attractive to consider front loading the FRAND issues for an ITC case for such a expedited finding?
Sure. Anytime you can get to the place of decision making and certainty that really is driving your case is going to be attractive to organizations dealing with those specific issues. And any issue that drives really the business decision is going to be advantageous to be in the beginning. So I see that as a very positive opportunity to start to put some of those matters up front, so that you can then move on. Because I think it's the speed and timing, and that's what you're really getting with an opportunity to be at the ITC as well.
And back to you, Hassan, in regard to the cost associated with the ITC, which I think is one of the, we're looking at our pros and cons. I'm with Kim. Speed is the big pro. There are other pros to it, but probably the biggest con is perhaps the price. Any thoughts on having a front-loaded approach to a FRAND case as a strategy for a patent owner?
Yeah, I mean, anytime you can get that sort of guidance and resolution early, you're going to save costs significantly. I mean, you're seeing around the world elsewhere where courts are kind of going past the patent issue and jumping straight into what is FRAND. And sometimes being DJ'd, maybe in the US too, DJ'd for what is FRAND is what I'm doing FRAND. So if we can jump and short circuit, costly litigation, get to the issue that the parties are really interested in resolving for a lower bill, that's going to change the analysis from the business side as whether that venue is attractive or not.
So Tim, just coming to you on that potential new tool, any initial thoughts on whether you'll see a patent owner or a respondent try to front load the FRAND analysis at the ITC?
I think it will rely a lot on the guidance and what is expected to happen in that trial. I think it is important that we look at both parties' behaviors, and determine, there's always this argument about hold up and hold out. And, I think both parties have obligations, and generally you can get down to the issues. And if in a case where both parties maybe have put FRAND offers on the table and counter offers, then you got to kind of look at, okay, what's the process from there? The UK has at least shown a willingness to take that to, making a decision on what is a FRAND rate, and they'll look at all the evidence from both parties. You got instances where maybe one party is acting, in a proper manner and the other one is not, and that also brings up an interesting case. But I think the use of an injunction, it is important to get deals done. So it is an important piece. But I think that's all under the assumption that, at least one of the parties is acting in a FRAND manner. So I think that's an important part. And if we can get that out early, I think that'll go a long way to, being able to help settle disputes.
Yeah, it's an interesting dynamic. The ITC has scrupulously avoided any attempt to say it needs to set a FRAND rate or determine a FRAND rate. So not only has the ITC never set a FRAND rate, it's avoided doing so. And I think the general understanding is FRAND only comes up in the context of an affirmative defense. So what's interesting about front loading the issue is you'd be front loading whether holdup occurred. If holdup didn't occur, there's no SEP issue in regard to the ITC case. I'm not saying there can't be any public interest issue in some manner that might come up in a different manner, but the holdout versus holdup is the present state of the law, and meaning that the respondent needs to show there's been a hold up. If there's not, it's over. I'll also mention that past attempts to stay the ITC case to let a rate be set in the district court have also failed. Those go back all the way to the interdigital cases in the early 2000s, and it's happening again right now in the case in Delaware, which one of the panelists brought to my attention, which is is that the Phillips Thale case? Is that what that case is?
Yeah.
But in any event, there's never been a rate setting by an ITC court, by an administrative law judge or the commission, and they've never stayed a case to set a rate. So those are very interesting dynamics that I think bode well for future efficient use of the ITC. Just one quick side note, there is a question about whether there's a difference in cost between asserting SEPs versus non-SEPs. I think that's an awesome question. The short answer is, in my experience, the SEP cases cost more than the non-SEP cases if you actually try to prove infringement of the accused product. They cost less if you simply rely on the standard to be the basis of infringement. And I think it's worth noting that a little less than half of all SEP litigation in the United States, that's 2001 to 2002, have failed on infringement, meaning only 49% of the cases have won on infringement. I think that's lower than the rate in non-SEP cases, and that may seem curious, but it generally is because people try to shortcut the infringement to read on the standard instead of the product. So I'll answer it, I think, more succinctly and say it usually costs more to do an SEP case if you're going to win, and it'll cost less if you want to lose. So I don't know if the panel wants to respond to that question, but I thought it was an intriguing question. Does anybody want to throw their 2 cents in on that? And you can feel free to disagree with me too.
I happen to agree with you, because basically what you're doing is you're taking a look at that standard and you're looking at what's really published and so forth. So, but to dissect and go to the product takes that extra layer of peeling away the onion. And, so people definitely rely on the fact that you're saying, oh, we are practicing that standard. And by virtue, if your patents are covering that standard, there's an infringement. But in reality, you really need to take that next stage if you're gonna really support and prove your case to 100%.
Tim, Hassan, any comment on that before I jump to the next question?
I agree with that.
Yeah, you can't dispute that if there's fewer issues, it'll be more cost effective.
I do think, as one other tangent on that question, in some of the other jurisdictions, particularly in Germany, I think that an SEP case is generally easier to prove up, and that they will be more appreciative of using the standard as a basis for infringement. A little different approach there. But we're going to get to Europe in a little while. Kim, back to you. Have you seen some tangible results from patent owners filing SEP actions in the ITC?
Yeah, you're seeing some kind of results. I don't know if they're more tangential or really how they're going, but you see a couple things like the Nokia case, the Nokia with Lenovo, where there is a case filed like an H.264, so the video codec side. And shortly after the case was filed, there was a settlement. So, didn't get to some issues again, but you're really driving using the forum. And so that's always a positive aspect, driving using the forum. Similarly, you have the Ericsson-Samsung deal where, the parties entered, I think it was almost like 7 months after the case was filed, that there was a deal that was done. So what you're really seeing is some kind of using that forum to drive some deals. And frankly, that injunction component is a big driver. That's where people are fleeing the U.S. to go to forums that have that. So if you have this opportunity to utilize that and you're capable of doing that quickly and hopefully a little less money, then you're better off.
Just following up on that answer from Kim, interestingly, less than 5% of SEP cases filed in the United States in the last 20 years have been directed to H.264 or H.265. So it'll be an interesting trend to see if that picks up. It's generally considered to be a spot that's under litigated in the United States by observers, but it's interesting to see that one of the recent cases was in fact directed to that technology. Tim, how do you think the ITC? Do you think the ITC can be a tipping point in driving licensing, and any experience with that?
I think right now, it's part of an overall litigation strategy. I think that these companies typically, they'll litigate in many jurisdictions all around the world. And the ITC is an important part of that. And certainly the U.S. market is a critical market for most of these companies. So I think it's an important jurisdiction to use, and part of an overall strategy. I don't know if you could say that the ITC is what kind of causes these agreements to be finally made, but it's certainly an important part of it.
And kind of focusing a little bit more on the injunctive element that I think each of the panelists has mentioned already. Hassan, is it, I know there's a bit of a divide here about what really is available at the ITC. Is injunctive relief really available to SEP holders in the U.S., in your opinion?
It's unclear. Somebody asked me the same question 2 weeks ago. And my answer was, well, my gut tells me for some reason it isn't, but I don't have a good reason why it can't be. And I think the issue is it's uncertain because of this FRAND defense and what would happen if you're seeking an exclusion order against someone who says they're entitled to a license. So I'll just say it's unclear. And that's part of what goes into the cost-benefit analysis I spoke about earlier. But on the flip side, uncertainty also drives deals. Right. So the fact that it could happen moves the needle in negotiations and between the parties.
Yeah. And back to Tim's comment, some of these large disputes, no one wanted to turn the card over to see if, in fact, an injunction would arise. I guess neither the innovator nor the implementer probably wants to test that water. But Kim, following up on that, should injunctive relief be available to SEP holders in the U.S.? You're seeing a little bit of noise in the sidelines about like maybe eBay coming into the ITC. Any thoughts on injunctive relief being available to SEP holders in the U.S.?
Well, I definitely think there should be availability for injunctive relief. I mean, you're really looking at the fact that in a global setting, there is that opportunity. And so you're really restricting some of that in the U.S. as well. And so therefore, it's really not driving innovation, not driving, the country's movement forward in a lot of these areas and venues as well. So I think what it does, it allows, I used to joke about it before, but it keeps the adult in the room, right? So the biggest thing to kind of eviscerate some of the deal-making opportunities is eBay. So to put that adult back in their room, to get parties to come to the table to say, hey, we've got to settle this and get these things moving. So I think there should be.
Well, following up on that comment, I think it's no coincidence that jurisdictions where an injunction is available are the most active jurisdictions outside of the United States, I think for the same reason. Yep. So, Tim, back to you. We touched on this briefly before, but should the ITC be part of an SEP holders litigation strategy?
Well, I think in the U.S. it almost has to be, right? The Thales example that you talked about earlier is a good example of you got to have a multiple jurisdiction strategy. I mean, if you use the ITC because that's the only place you can get the injunction, the ITC is not willing to set the rates, as we discussed earlier. You need it. And that's what I kind of like about, and I know we're going to talk about a little bit about what's going on in the rest of the world, but in the UK, you got one court that kind of does it all. They're willing to give the injunction, but they're also willing to look at the agreements and the offers that are being made by both parties. And at the end of the day, they come out and say, this is a FRAND license. So I think that there's, it's a two-pronged strategy in the US because you can't get one court to kind of listen to or to judge both issues. You can get the injunction in one, and maybe you get a ruling on a fair price from the district courts and from the federal courts. So I think it is an important part in the U.S. But frankly, I'd like to see something a little bit more like kind of a one-stop shop. But
all right, that's helpful. We're going to get into some of the complementary nature of filing even outside of the United States in combination with the U.S. a little later. Kim, just back to you. You've touched a little bit on the benefits of the ITC. You mentioned earlier speed as the primary benefit. Any other, benefits come to mind in regard to including the ITC?
Yeah, I definitely think that speed is, one of those big primary factors that you take into consideration. Obviously, the ITC is, as it also was mentioned, is part of the larger strategy of when you're taking a look at what the case is and what you're pursuing, not only in the US, but globally. But it can also be a very good tool when there is multi-range of respondents and defendants and quite a few entities. You could be able to utilize that as a very positive tool to be able to attach to several different entities. And then, of course, as we spoke, it's part of the strategy, serial filings. There's always different ways to have one case going and adding on to your ITC, or have your ITC and other cases going. So it's a part of a larger litigation strategy that can be very effective.
And that concept that Kim is referring to, I think, about having a kind of a portfolio of risk created is sometimes called inevitability. And I agree with Kim completely that it's one of the ways to kind of ratchet up the amount of pressure you can put into the mix. I guess I would also mention, earlier there was obviously the comment that an injunction is the outcome of the case. That's otherwise not likely available in the United States post eBay for many companies. All you have to do is look at the Apple versus Samsung case, where it was near impossible for Apple to get an injunction against a direct competitor. I think it took 7-8 years to get it. By that time, the accused product was off the market. The other benefit I think that we haven't touched on, but it's not central to today's conversation, is IPRs are virtually ineffective in staying an ITC case, which is, considering how effective they are at staying district court cases, is a fairly significant distinction. But back to you, Hassan. Are there any specific benefits to SEP holders that you'd like to highlight or identify?
The speed and the remedy are clearly, things we talked about is what makes it interesting for SEP holders. Another difference, I'll call it, that's there is the jury element versus district court and ITC. We can leave it to the audience if they think that's a pro or con. But one thing to keep in mind is what we're seeing in the recent Phillips case and the Tails litigation and an amicus briefs filed in Delaware. The fact that a patent owner is going to seek an injunction in the ITC is triggering another litigation of whether you're even allowed to do that on a FRAND encumbered patent. So, I will say there are benefits, the ones we talked about, but, a downside is you might be creating risk for a cause of action in a district court case that that filing was inappropriate.
And there's a bunch of other dynamics that we could continue, that we're going to consider in regard to international elements. That'll be the next topic that we're going to jump into. But before we do, there is a question up here about the ITC is a great forum, but its only remedy is exclusion orders, and SEP litigation is always looking for monetization. Is anyone troubled by using a legal process for a result that you don't want to force a result that you get from the ITC? I guess my short answer, is first, I think there's plenty of cases where the injunction is actually the preferred outcome. In SEP cases against direct competitors, I even think an injunction might be more valuable than the royalty that would arise. But I guess the trouble I have with having a philosophical challenge with the ITC being used as a lever arm in instances where a willing licensor is involved is the only context in which that case could go forward and be successful is if there's holdout occurring, right? So in the instance where holdout's occurring, I think the concerns about equities favor the patent owner. By definition, if there's hold up, an affirmative defense would prevail and prevent the case from going forward. So my short answer is no, that's not troubling. But maybe it's worth it to just run around the panel real quick and take temperatures. So Tim, any initial thoughts on the question?
No, I think that's right. Again, it's got to be part of a bigger strategy. I can't think of a case, and there might be one, where somebody has only used the ITC. It's usually always part of a multi-pronged strategy. The goal is to get a licensing deal done. And I think, in the end, that happens more often than not. Whether it's the ITC that actually pushes it over the line or something else. But these things tend to, kind of take their time and go through the process. but frequently, especially the bigger cases, they tend to get the results, I think, and you got to hope that both parties walk away with a little bit of pain, right?
Understood. Kim?
Yeah. So first of all, a great question, Russ. And Russ and I went to law school together, so I'm used to his theoretical questions. But sometimes you do use different tools that may have a different end result to drive what you're looking for a business result. And I'd also caution the word always. It's not, is there always the result to look for money, or is there some kind of other result in there? But if you really are looking for the deal to happen, what you're really trying to do is drive the behavior. And one of the things that you need to do is say, well, what's going to be the most effective tool to help me drive that behavior? And if the ITC is one of those many different facets, I think it's a very viable tool, and it's good to use.
Hassan, any thoughts about that question?
SEP is outside of SEPs. Any dispute with parties, when you're trying to get a settlement, it's not always the case that what you're asking for in court is what you want in the settlement. And so, it's about getting leverage in the settlement discussions, more so than it is trying to win in the case. I think that's just a factor of, talking about these risk profiles. Mike, you mentioned inevitability. That kind of concept, it's a piece, it's a tool. But it is true that more often than not, the patent owner is not actually trying to stop that person from selling in the U.S.
Yeah, the oddity really, in my mind, is if we take a step back and try to be as objective as we can be, is arbitration is virtually always offered by patent owners, and it's virtually never accepted. So there was a history where it was more common, and it does happen once in a while. But my point would be, it's hard to have anybody wear the white hat in these dynamics without looking closely at the history of the negotiations. And so I think they are case by case at this point. Tim, we're going to switch the gears to the global SEP disputes. And in some ways, I guess you can't really think of SEP resolutions without thinking globally, right? So are there any developments in the SEP disputes globally that kind of grab your attention these days?
I think the most obvious ones are kind of what's happening in the UK. As you stated earlier, I actually had the privilege of being an industry licensing expert witness in that case. And, it all started with Unwired Planet Huawei. And, I think the UK court's an interesting court because they don't have any big industry there that's, really going to benefit one way or the other. Either side, right? Either a big major patent holder or a big major implementer. If you want to think about independence to the extent, that any of these countries have some independence, I think it's a good jurisdiction for that. But I also think that they did a very thorough job, especially, if you look at the Unwired Planet ruling, people look at that and say that was a big win for Unwired Planet and for the industry as a whole, or for patent holders as a whole. But, the courts actually favored Huawei's position in some of the key aspects, of the final agreement that they put out. So, I think, I just think that they're very thorough and they're looking at this very holistically. In the most recent case with Panoptis and Apple, they basically said, look, Apple should be willing to commit to taking a third-party license that's determined to be FRAND, even if that might occur a year and a half or 2 years from now. They should be willing to commit to that today. And if they're not, that's a pretty good indicator that, they're an unwilling licensee. And therefore, maybe injunctive relief would be something that would be available immediately if, unless they're willing to commit to taking that license down the road. Which again, if you think about this real logically, you have a hard time figuring out, what would possibly be wrong with that. I know Apple was trying to make a lot of arguments about the fact that, agreeing to take a license sight unseen, was a big part of that case. But, it's, if you look at that, they're going to have their chance to put their positions out. It's not really sight unseen, right? Both parties are going to get up and put the issues that are important to them and why they believe they should get what they are asking for. And if you got an impartial, thorough court system that can look at that, you should come out with a good result. And again, maybe both parties walk away from that not completely thrilled, but that's generally the way it is anyway. So,
well, interestingly, I think both Unwired Planet and Panoptis are, several years in the making and well north of several $1 million. So they're not efficient or cost effective, but I think the cases that will occur in the UK going forward will benefit from the jurisprudence that has been developed. And I think the UK will be a more cost effective and more efficient forum going forward. So a lot of heavy lifting being done by the UK court. I'm going to turn to Kim and Hassan and ask for interesting developments outside of the UK, but please don't be afraid to mention the UK if you'd like. So why don't I start with Kim? In addition to the UK, any other interesting developments you're keeping your eye on?
Yeah, well, we saw, the Sisville hire, case, and some of the results that occurred, after the Huawei ZTE decision, where they're taking a look at whether Sisville breached its FRAND duty and what that would look like, and what is that duty, and what is required of somebody like a Sisville that's in there. Ultimately, I guess they looked at that saying that they didn't abuse that market power that they had, but those are things that the courts are really taking a look at and being very critical to make sure that the parties, as Tim kind of mentioned earlier, what's the behavior? How are people acting in that as well? So, those are some that I was looking at.
Hassan, any thoughts on that?
Yeah, so I kind of view the UK as a sort of almost more like an arbitration where the court can write what the license is supposed to be, and then the consequence if you don't take it is an injunction, that we heard about Panoptis. In another jurisdiction like Germany, it's more like baseball arbitration where each side's judged on their facts and their behavior and their offers, and then the court decides, and they don't decide what it's supposed to be, they just know what it's not. But other than Germany, Germany is probably one of the more popular ones, I think, because it's speed of resolution for low cost. But we're also seeing like the Netherlands is following a similar approach. Probably in my experience, second behind Germany as far as getting experience in these issues. But Germany is really the main country where we're seeing a lot more evolving law on these issues.
Yeah, and on the Germany side, I guess what I think is it's not unique to Germany, but it's definitely Germany amplifies the issue, which is if you don't negotiate, that's not a successful strategy.
Right.
And if you hide behind, I haven't seen the agreements and other tactics that were, I think, the default position virtually in all the negotiations involving parties who were, reluctant licensees. That doesn't work over there very well. And I think it kind of goes back to Tim's observation about complementary strategies. I think not only is the ITC case in the United States virtually always accompanied by a parallel district court case. So that kind of goes back to Russ's question. There always is a district court case, at least in every instance I'm aware of where there's been an SEP case in the United States, ITC. There's been a parallel district court case on the exact same patent. So they usually don't occur without the other. But I think you also see in the strategies that we've been talking about, and Kim has just mentioned a couple of them, you'll see cases that will straddle the globe, right? Whether it's InterDigital or Nokia or otherwise, you'll see multiple national cases moving forward, either in series or in parallel to try to drive the right outcome. So it is truly an international chessboard. It is 2:43, so I'm going to jump to the question in the queue, although if time permits, we'll go back to China and India to further extend those thoughts. See if I can put this up so everyone can see it. There we go. Since numerous patent holders can cover any piece of a standard, if I was the complainant or licensee being sued for DI, I would be concerned about the broader implications of admitting to the operation of my own product any impact you have seen. Well, there's a lot in there. Who wants to take the first crack at it? Tim, do you want to take a shot at that?
I'll pass on that one.
Okay. Kim, you want to take a shot at that?
Well, I'm kind of dissecting the question a little bit. It's being as the licensee, being concerned about admitting operation. I think that if you're talking about in a licensing discussion, I think what you're really doing is I don't know if you need to admit it. You're talking about assessing a risk. Now, when you're getting into the litigation component, whether that's the ITC or the other forums, now we're into discovery. So it's what it is. You either are doing it or you're not doing it. So I think that I'm not really sure specifically where he's coming from the question, but I think if you're looking from the pre-litigation to the post, so you can assess your risk and you can understand whether you need to take that license or not. You do not need to admit anything. I kind of joke and $2.5 billion of licensing. I've never licensed a valid or infringed patent, but there's a lot of money that exchanged hands. So,
Kim, to your comment earlier, and this may be a different way to look at the question, you had made the comment, and we both agreed, I think, that just because you practice a standard doesn't mean you're conceding infringement of a standard essential patent. Correct. In fact, it's very rare that someone who's actually saying I'm compliant with the standard will concede that they infringe a standard essential patent. You may say that's a non sequitur, and in Germany, I think the German courts are more onto that notion.
Right.
But generally, the licensees don't concede anything, even after litigation begins. In fact, they'll say, we don't infringe the patent, and the patent isn't essential to the standard, and that's how they get around that dynamic. But Hassan, do you want to add, or Kim, do you want to add remarks on that?
So I don't have anything to add. You just have to be careful how you characterize your position, I think.
Mm-hmm.
But I certainly can see the risks of admitting infringement of every SEP by using the standard. I don't think anybody would advise an implementer to do that. So, but I think there's a way to get to where you want to be, get to the dispute. As Kim said, no one's going to concede infringement, even until the highest court just says it is. But we still settle. So it's about assessing risk more than it is about taking positions.
Yeah, and I think the whole panel agrees that it isn't necessary to concede infringement in regard to a standard essential patent as a tactic to get yourself into court or to defend. So I may not have answered the question properly, but I think that's the best shot we can give it. Without any other questions in the queue, and I'll keep my eye on for additional questions. We do have 4 minutes left. So what I thought I'd do is go to each of the panelists. And I'd say we haven't talked about the impact of India or China in any detail. So why don't I start with you, Tim? Any quick thoughts on India or China?
Well, I think, we've seen in the last 4 or 5 years, a significant uptick in cases being filed in India. So I think, again, that's becoming part of a global strategy. India is a big market. They've lost most of their domestic suppliers. So typically you're suing companies from outside the country, in India. China's interesting. I think they definitely want to be, on the global stage, and they should be. But I think we just have to see. I think people just have to get comfortable with the independence. Can they truly be independent? And if they are, that could become a very important jurisdiction. And you do see some companies testing the Chinese court system. But I think it's hard pressed to find somebody that went after a big Chinese company in China. Because we have to get over that hurdle for China to become real meaningful.
I just noticed there's some raised hands. Apologies. I see if I can quickly do a rapid round here. Pallavi, you have Pallavi Shah, you have the mic if you want to ask a question.
Thank you, Mike. So since this is about deal making, I have a very simple question. So can you talk a little bit about the waterfall, how the deals are structured at a high level, of course, and what are the different milestones for ITC litigation cases generally?
When you say deal structure, you mean the structure with the law firm or the structure with the licensee?
Both. I think the funder is involved, and so is the law firm, and so is the licensee, right, or licensor. So generally, how are these waterfalls deals structured?
I'll take a quick shot at that, and then frankly, anybody else could jump in. So generally what happens, there is no one size. I think everybody has different ways to do it. If you have an enterprise that doesn't require litigation financing, I'll leave those out because that's an easy answer. In the instances where you do, generally there's an investment hurdle that could be anywhere, from 1.5 times the original investment to 2.5 times, depending upon the risks involved and the execution strategy. And then after you've satisfied the investment hurdle, let's say it's 2x on a $10 million investment, after 20 million, because that satisfies the 2x of the $10 million investment, you would split it. And those splits run in every possible direction, but they include the patent owner, the law firm, and the investor. Generally, the investor is getting a small number there because they've already got their investment hurdle. Some of the classic arrangements are 40-40-20, 40% to the patent owner, 40% to the law firm, and 20% to the investor. That's just one random shape, but there could be many others. I don't know if Hassan, Kim, or Tim want to take a shot at that.
Yeah, I think it just depends on what your funder is, the risk that they're willing to take and what they've assessed that for their return rate. So I've seen them come in all different shapes and sizes, some what you just explained, and some, where the funders are going to want a little bit more because their risk is even, very heavy, or they're very happy that they got it up front and good to take a much smaller piece at the back end. So it's very case dependent.
Yeah. And what's implicit in that, of course, is the law firm generally takes a fraction of their overall fees, whether it's 50, 60, whatever percent. And then there's often a cap involved. Well, Pallavi, I'm going to jump to David just to see if we can sneak in one last question. David, I don't know if you can hear us, but if you can, we'll give one panelist a chance to answer your question.
Yeah, g'day. So I had a question regarding one of the ITC cases that was, relevant to where I'm at, and this was Samsung versus Dynamics. And kind of the conclusion from the ITC's ruling was that, Samsung did infringe Dynamics patents, but then didn't establish Dynamics as having substantial domestic revenue or presence, even though Dynamics actually provided a considerable amount of detail on their R&D expenditure and factories, employment, and so on. So is this really a viable forum for, SEP litigation, and especially for, NPEs, given this kind of high bar for proving domestic revenue?
So I'll take a quick one-liner, then I'll hand it off. Domestic industry is one of the most sophisticated and complicated things to show at the ITC. It gets harder every time I go up the hill on a case because the rules keep changing. So I would just say to you, the domestic industry is virtually completely detached from the SEP analysis. There is no overlap to me off the top of my head, but your domestic industry is not simple to satisfy. Kim, why don't I throw it to you for a quick comment?
Yeah, I think they're definitely two very distinct topics. I think what you're probably getting to, though, is the kind of business model that's run by maybe a potential licensor, because there's SEPs obviously that are held by operating companies, and SEPs that are held by more of a MPE. So it really just depends on what that business model of the organization is. So that's where the overlap and the confusion. But that's a hurdle. I mean, dealt with that in past lives as well. So it's something that it takes somebody like Michael a very, very detailed analysis to know as a threshold before you're even getting into that ITC component.
Good answer. So I think we have to move to the networking time. Wendy, is that
Thank you.
The chance? Thank you, David. I'm not sure if we automatically move to the networking time or whether it's a transition that Wendy triggers. There she is. Wendy saved me.
Oh, you're muted.
Wendy, you're muted.
Okay. All right. Try it again. What a fantastic interactive discussion. Thank you all. Thank you to the panelists, Kim, Hassan, and Tim, for sharing your time, insights, and expertise. And thank you to Mike for moderating today's discussion. Great job as usual. We're grateful to you and the entire Mintz team for your support and sponsorship of today's event. Now, we're going to transition to the lounge. We usually have more time for this, but the good news is that we can just keep it open until the last person leaves. So, we do have 5 minutes until 3, the official end time of this event, but feel free to stay in the lounge, hang out. When you get to the lounge, I'll transition us there shortly. You'll see tables for general networking. You can also choose to join your appropriate last name table if you'd like. There's an Ask the Speakers table, which hopefully some of our speakers can join us there, as well as an Ask Mintz table for some expert advice. Before we head over to the lounge, I just want to take a last moment to thank our speakers once again and thank all of you for joining us. Our next event is the 8th Annual IP Dealmakers Forum on December 6th to the 8th in New York City, as well as virtual. If you'd like to attend, make sure that you sign up soon. Space for the in-person event is very limited, and we do anticipate selling out soon. So I hope to see you there at IP Dealmakers and in the networking lounge where we're all headed right now. Thank you.
Thanks, Wendy.
Thank you.
Thanks, Wendy.
Thanks, Wendy.